Okay. Hello, everyone, and welcome to today's SOAR webinar series on Hearing Skills Building Part 2 on Pre-Hearing Preparation. Today's webinar is presented by the SAMHSA SOAR Technical Assistance Center at Policy Research Associates under contract to the Substance Abuse and Mental Health Services Administration of the U.S. Department of Health and Human Services. My name is Pam Hine. I'm a Senior Project Associate with the SAMHSA SOAR TA Center, and I'll be moderating today's event. Before we officially begin, housekeeping items before we begin. This webinar is being recorded and will be available for download on the SOAR website in about a week. Your lines will be muted throughout the webinar. Right now, you may download the PowerPoint slides. You have two options. First, if you look to the top left of your screen, you will see the file icon, and then save and click Document to download materials. The second option is to visit the SOAR website, where now you'll click Webinar, go to the Webinar tab, find today's topic, and the PowerPoint slides are ready to download, along with several other handouts, which are at both locations. At the conclusion of the webinar, you'll be directed to a link for an online evaluation. Value and appreciate your feedback and use it to improve and inform future SOAR webinars and activities. So we ask that you take a moment to complete it immediately following the webinar. Let's very briefly review the agenda and our learning objectives for today's webinar. First, I'll provide a review of just a very brief review of the webinar we did this time last year. And on today's webinar, we are very fortunate to have two attorneys, public assistant attorneys, Sarah Anderson, senior attorney at the Health and Disability Unit at Greater Boston Legal Services in Boston, and also Linda Landry, staff attorney with the Massachusetts Disability Law Center in Boston. At the conclusion of the presentation, we'll have time to take your questions and answers. Briefly at our learning objectives. We hope after this webinar, you'll have a better understanding on how to read and respond to the ODAR acknowledgement letter, which goes to applicants. You'll also learn how to review and understand some of those key documents in the applicant's electronic folder. You'll also be introduced to how to develop a theory of the case and learn how to interview the applicant with a focus on developing that theory of the case. Linda will also give you an introduction to some key SSA regulations, rulings, and a guide called the HALIX. So you're introduced to that as well. So now I would like to present Kristen, our project director here at the SOAR TA Center, who will give our welcome this afternoon. Kristen?
Thanks, Pam, and welcome everyone to today's webinar. I just wanted to kind of say a few words about resources and tools that the SOAR TA Center has for hearings and appeals. Over the last few years, with our subject matter expert, Pam Hine, which she hasn't mentioned, has helped us to greatly expand the number of resources we have for you all who are assisting applicants with their appeals. And if you look at the topics page on the SOAR website for appeals, there are 13 articles addressing everything from continuing disability reviews to reconsiderations and hearings and on-the-record decisions and hands tips for reviewing a denial. And so there's great tools and information there that we hope you guys will take a look at. If you've been through the online course, there are new articles to help walk people through, and we're of course doing this webinar series as well. So I just want to kind of bring your attention and thank you all for participating today.
Kristen. Before we begin the presentation, we want to gauge your familiarity with hearings, specifically whether you've represented an applicant at an ALJ hearing. So we'd like to ask, it's multiple choice, so answer A if you've never, so none, B if you've represented between 1 to 5 applicants, and C if you've represented more than 5 applicants. So take a few seconds to answer that poll. So thanks very much for participating in the poll. So similar to last year, this is the same question that we posed during last year's webinar. So we have about 47% who have not completed an application. That's actually a lot lower than our last polling from last year. And 1 to 5, 14%. So that's increased a little bit, as well as more than 5. So we're seeing somewhat of an increase in the numbers from last year. So hopefully that's due to some of the educational tools that we've put out for you. Again, thanks a lot for participating in the polls. So before you get to hear Sarah, I'll just do a very brief review of last year's webinar. So as said, this is one of our tools that we did, the webinar of June of last year. So again, you'll find that on our website under the Webinars tab. So you'll be able to see the PowerPoint slides and listen to the audio and see some of the tools that we uploaded as well. And part one, last year's webinar, we focused on both preparation for a hearing as well as presentation. We talked about, gave you an overview of the Office of Disability Adjudication and Review, called ODAR, went over the role of being an authorized representative during the hearing process. We went into how to write on-the-record reviews, successful ones, request dire need to expedite the hearing, so things that you can do in lieu of a hearing. And in the presentation portion, we focused a lot on what a hearing room looks like and some of those basic protocols when you enter an ODAR hearing office. And this is our appeals issue brief that was written a little over a year ago, so you can go check that out. That has some, again, some really useful tools on the whole appeals process as well. So just a brief review to get everybody on the same page. We all know that individuals have the right to appeal a denial and/or a termination of their SSI and SSDI claims. To file an appeal, that must be done within 60 days of receipt of the denial of reconsideration. But know that there is good cause for late filing, and we have some handy information on how to request good cause if you're beyond that 60 days. And we went heavily into Social Security's iAppeal for filing the appeals online, which is the suggested method. And some of our newer articles are on the iAppeal process. I would direct you to go take a look at that. And you can also mail your appeal forms in, and always ask SSA for help, you know, if you need it, if you have any question, or contact the SOAR TA Center too. We'd love to help you with any questions about that. So we know that it takes about a year or more to get an in-person hearing. And in some areas, it's almost 2 years to wait for a hearing. And again, that varies by hearing office and location. So you want to check out some of the statistics on your hearing office. And we did provide for you a slide which shows you how to access your hearing office and be able to find out how long a wait there is, and some statistics on the actual judges themselves. So that's going to be a handy tool for you. And I would just encourage you to read the issue brief and look at our webinar from last year to learn, to refresh your memory on how to do on-the-record decisions and more about compassionate allowances and cherry cases for individuals who have terminal illnesses. So, you know, you really do need to make the case to the ALJ why he or she should allow the claim without an in-person hearing. So I think it's another role that the SOAR practitioner can have to really help the individual be awarded and avoid that long wait for a hearing if possible. Next slide. All right, well, now I'm going to hand it over to Sarah, who will be our first presenter today. And Sarah and Linda will both be tag teaming a little bit too. So, Sarah, I'm going to hand it over to you.
Okay, thanks very much, Pam. First I would just like to say thank you to everyone on the webinar. I'm really delighted to have the opportunity to present this information to you folks today. I just think SOAR does a terrific job, and certainly as does PRA. So my hats are off to you. I see that most folks are not too familiar with how to do a hearing. Just some background, you may have heard this before. From this particular slide, I think the thing that you want to take away is that the nationwide core of ALJs hear cases de novo. This is a really important concept for people to understand, because it means that they take a fresh look at the case. And in fact, when you appear before an ALJ, some of them will actually tell you that they take a fresh look at the case. They're not just looking at what DDS did upon reconsideration or at the initial case. They have the ability to look at the same evidence and come out with a different determination based on their understanding of everything that is in the record. There are 10 regional offices, 168 hearing offices, 5 national hearing centers, 2 national case assistants. I think that the estimate of 1,300 ALJs may be up to 1,500 by this point. And as we said, there's a link to the ODAR office locator, and as Pam mentioned, you can actually go on the Social Security website and find how long it will take to get a hearing in your particular location. Just the national hearing centers, they only hear cases by video conference. Linda's going to talk a little bit more about those in a few minutes. But people generally don't have a choice as to whether they're assigned to a national hearing center or not. Anyway, most cases are heard in the local office. Just wanted to put this slide up again is to remind people that you do have to submit a signed 1696 form. What's important about this is that Social Security has rules of conduct for representatives, and they're in the regulations and probably in the POMs as well. And what's important when you're at this stage of representing an individual is what are the authority of your representative, what things can't you do, and also to be aware that there are sanctions for prohibited conduct. Now, we're not suggesting that anybody's going to be sanctioned, but I think the message really is that Social Security takes representation and who can be an authorized representative extremely seriously, and they pay attention to these rules. The first thing that should happen after the claimant has filed the request for a hearing, by the way, that's often done in the local office, and then they send it on to the local hearing office. But if you've done this and 3 months have gone by, for example, and you haven't received a letter from ODAR called an acknowledgement of receipt of hearing request, follow up on that because in some instances you want to make sure that it actually got there. Was it delayed? Did something happen to it? Wasn't it filed properly? So once you get into this, you really want to make sure that you follow up on it. And really, that's no different than when you follow up with DS and you're representing an individual at initial or reconsideration. Excuse me. In the materials that we've sent around to you and are available on the website, we have given a copy of the acknowledgement of hearing letter. The one I've given you is from the Boston office, Boston ODAR office, which is about a year old. It runs about 12 to 14 pages, and that sounds like an enormous amount of things just for an acknowledgement of a hearing. But it really is designed to tell you what's next in the hearing process. It should be addressed to the individual client. Now, this is a letter from the Boston hearing office, and it may be a little different than the one you get. Particularly for you folks who have already done a hearing and you look at this, you may say, well, my letter didn't look like that. And it may not have. You know, they all probably send out something that looks a little different. In the Boston,
Sarah, this is Pam. If you look above, you will see ODAR hearing. You have the capability to click that on.
Oh, thank you, Pam.
There you go.
Okay, so this is just what I'm referring to, and if you look down on line 3 of the letter, it says, we will notify you at least 75 days before the date of the hearing. That is a Region 1 rule, and we'll talk a little bit more about that. Region 1 is basically New England. They have something called DSI, Disability Service Improvement, that they started here as an experiment back in 2007, and most of it is no longer in effect, but the 75-day advance notice of a hearing. So that's one difference that you may notice here. If you go down to, okay, so that's the first page, and then they also give you information in this notice about the VCR hearings, and Linda will go over that. But basically, this is your opportunity to say yay or nay to going to a video conference hearing. They also include just some basic information on what happens next, and they also are looking for you to sign and return a medical release form and an authorization to disclose information to SSA. The reason for doing that is that the ALJ may want to send out for some information, and he's looking for updated release from your client. Okay, as I said, they ask for updated medical vocational information. ODAR will be asking you for that, and certainly when you're representing an individual at a hearing, that's really part of your job. I mean, remember that if it's taking 1 to 2 years to get a hearing, you may have some updated medical evidence. Finally, the next point is simply scheduling a hearing. It is up to the administrative law judge, but see if you can agree on a time and date before the notice of hearing is sent. The notice of hearing is actual formal document, and it tells the client when and where the hearing is going to be. So before that actually goes out, see if you can agree on a date. And talk to your client. You know, you may find that somebody is taking care of a child, or they're working part-time, or they have a long-standing medical appointment, and they may not like the specific date and time that's been proposed. So talk to your client. Okay, Linda, I think this is you. The conference. Oh, I have to hand you the.
Okay. So you probably noticed on the document that Sarah just pulled up, so the introduction letter after a request for hearing for administrative law judge appeal has been filed. You get this welcome letter, and one of the things that was included on the first page was that they may want to schedule the hearing by video teleconference. This is something that SSA has been putting. It's easier than having and cheaper than having administrative law judges travel, and they think there are certain efficiencies involved. Some people are very pro video teleconferenced hearings. Some people don't like them and don't want to have their clients appear that way. Think they might be prejudiced by not appearing in person. So it's a personal decision between the claimant as informed by their representative. But if claimants don't want to appear by video teleconferencing, then they must object when they get notice that their hearing will be scheduled by video teleconference. They must object within 30 days of the notice, and then they will be put in line for an in-person hearing. I mentioned Social Security has also established national hearing offices, and if a case is sent to a national hearing office, then it will be most likely a video teleconferenced hearing. And again, people can still object within 30 days of the notice that the case will be held by video teleconference, that they prefer an in-person hearing. If you object within the 30 days, you don't have to give a reason. You just have to reject the video teleconference hearing. One caveat here, though, is that if people change their residence after or before the hearing and rejecting a video teleconference hearing, then Social Security gives themselves the right to schedule it any way they want to. And I think the reason for this is that many people thought that people were trying to judge shop by changing residence. I have no idea if that's true. There are limited good cause reasons for missing the deadline to object. One big one, of course, is non-receipt of the notice, which can happen if people's address isn't correct at Social Security. Really important that people make sure they keep their addresses up to date. There's also the usual good cause reasons for serious illness, death in the family, serious crises with the individual or their family where they couldn't attend to important business. And then they're also supposed to take into account whether the individual had any physical, mental, or linguistic challenges that caused them to read the notice, understand the notice, or react. Read for Social Security, the New England states is also another area where there's a difference here with the good cause reasons. You probably have to go a little harder to show good cause in one of these states for not having a video teleconferenced hearing. It's important to pay attention to these notices and make sure that your clients are looking for them if you have your clients early enough, so you have the opportunity to weigh the pros and cons in case. I mean, one of the big pros may be that sometimes you can get a quicker hearing. You're not in the same place as the AJ. There are sometimes participants in the hearing, other than the claimant and the representative, will be by video teleconference hearing or by telephone. These would be vocational experts or medical experts that may be scheduled at the hearing. Increasingly, these folks are here remotely, again, by video teleconference hearing or even on the telephone. And sometimes the entire hearing can be by telephone. This is not a favored way to conduct a hearing, and I believe so far Social Security limits this to people who are in prison or perhaps other institutions where they're not allowed to have the hearing, the person can't get out, and there's also not video teleconference technology available in that setting. Okay, I think this is me again. So, many Social Security hearing offices are starting to use pre-hearing conferences. One of the reasons Social Security does this is because of the long waits for a hearing. I think Sarah mentioned it can be a year or even 2 years in some cases. And in that time, some people may no longer want the bid, or people may have disappeared, or they have no idea how to get ready for a hearing. So one of the things that Social Security is doing, particularly where there's no appointed representative in the fall, is to schedule a pre-hearing conference. Call the individual in, find out if they're still interested in going forward, perhaps try to find out if there's anything new, find out if they want a representative, and tell them how to get one, those sorts of things, trying to make sure that the hearing list is up to date. Sometimes, maybe particularly in non-disability case issues, they may call the individual in for a pre-hearing conference with or without an appointed representative to narrow the issues. For example, an overpayment case, to find out whether there really is about fault or ability to repay. So watch out for pre-hearing conferences. Try to talk to other practitioners to find out if the hearing office does use pre-hearing conferences. Caution is that if the claimant doesn't show up for a scheduled pre-hearing conference, the case may be dismissed at this point. That is another reason to get the word out there that people send in their acknowledgement forms, because if the individual did not send in their acknowledgement form and the case comes up for a pre-hearing conference or even the hearing and the individual doesn't show up, the authority has to do less to find out if there was good cause for a failure to show up. There is a HALEX here I'm going to show you on the pre-hearing conference. Let's see. Yes. It's not a particularly good copy, but you can get the idea, and I think it will be available to you online in a better copy format. At any rate, this is HALEX, and it is, HALEX stands for Hearing Office Law Litigation, I forget what the X stands for, but is the procedural manual for ODAR, for ALJs and the Appeals Council, and it's an important set of rules to get to know. Available on SSA's website in the Program Rules section, so you can find it there. And this one, I-2-1-75, is about pre-hearing conferences, and it's a relatively new so it's something that I always check to make sure that I'm up to date on all the procedural rules. And this does talk about, in the general section here, that Social Security can dismiss if the individual fails to show up for the hearing conference, and particularly in Region 1. We seem to be the region where a lot of things are tried out first. And you can see the purpose for pre-hearing conferences down below. So it's a good one to be familiar with. It's not done.
You got the presentation tab.
Thank you. All right. I think we're ready to move on.
Yeah.
Pardon me?
You give me the ball. Yeah, got it.
All right.
Okay. So the next, that's pre-hearing conferences. We're going to move on. Okay, so this is at the point, once you've gotten the notice and you've figured out whether you want a hearing in person or by video conference, you still have a lot of work to do to prepare your case. And so one of the first things that you should try to do is to get a copy of the record that ODAR is using. And that should be available to you once they've sent out that acknowledgement of receipt of hearing request. And you may get that. Your client may show up in your office with it or bring it. if your 1696 is on file, they can send it to you. The other thing is, I think at this point, virtually all the disability cases have electronic records as opposed to paper records of the claim. There had been a period of time when you'd have part of the case in paper, part of it electronic. I think, at least with respect to disability cases, that's no longer the case. I want to spend a little bit time talking about parts of the electronic record, and the first one I'm going to just mention is something that's called case documents. You can see the title. There's a better copy available online, and certainly when you get it on your own computer and see it, you'll be able to read it better. But if you look at the top, underneath where it says Document Index, you'll see two lines that give you a great amount of information about the claim and what it is presently that is really worth taking a look at, because sometimes, for example, this may be you weren't the person who filed the request for the hearing, and you really know whether the client filed for SSI or SSDI or both. If you look on here, you see claim type, and in this case, if you look to the right of the hyphen in claim type, there's a Title 2, and under that, there's a T16. Title 2 is SSD, Title 16 is SSI. This tells you, obviously this is an old case since the last time this document was changed was in July of 2012. By the way, you might wonder, well, who really cares? But you may find yourself getting 2 or 3 of these documents over the course of the year or two that you're waiting for the hearing. And so you'd really like to know, am I looking at the most recent information that ODAR has? Give the application date. Here, 6/21/2011. Alleged onset. This is always a key date for Title II. The ALJ is going to be looking to see when did the person say that their disability began, and then right next to that is last insured, 12/31/2013. Again, that's a date for Title II you're going to want to know. Sometimes you may be confronted with a case that the date last insured was, 5 years ago, because a client has not worked in a very long time, and yet they filed for Title II benefits. Or you find that it's 5 years in advance because of the date that you're looking at this document, because the client just stopped working recently. So this gives you a lot of information. Then each of these is broken down into specific parts, and both case documents and the next one we'll take a quick look at, exhibit list, the same parts. Briefly, Part A is payment documents or decisions, and so this tells you what did DS decide about this case. What is the information? And the key one to look at from my point of view are that DDE, or Disability Determined Explanation, the earlier date, which would be, I guess, Exhibit 1A, is from July of 2011. So that would have been, it's 8 pages. SSA goes into how they, decided the decision, what documents they used, what they looked at. And then the second DDE is from October of that same year. So that tells you, since it's after the July date, that would be the reconsideration one. Again, 10 pages. So those are documents that will tell you a lot about what DF said about its case below. Part B goes through the jurisdictional documents, notices, and it's in here. You'll see the request for the hearing, your appointment of representative, since you have access to this, it should be in here. One thing you may find out is that there is a second appointment of representative, and lo and behold, somebody else has filed to be a rep in this case as well. Claimants don't always tell you that, or they don't know that the person filed this document. So this is where you can find out who SSA thinks is the representative. Finally, if you look at the end of Part B, it's T2 reconsideration notice, T16. Those are the actual notices that tell them that you've been, what's happened in your case below. Disability development, this is certainly a key item. It tells you certified earnings records. That's what Social Security's record is of when your client last worked and how much they earned. And Social Security these should be in the file when you first get it, when the person just files for the hearing, and then they will update this prior to sending out the hearing notice. So it's always important to check this. Your client may know that they worked 2 or 3 old jobs, but gee, they just don't remember the dates. This is how you can check on your client's memory and to see exactly what they had said. And believe me, the ALJs look at this. So don't think that because they're hard to read or I don't understand them, you really learn how to, review these and kind of spend the time looking at them. And clients often just do not remember all the details of when they were working. Here you can see applications. The applications for both those should be in there as well. Okay, so I think I want to go back to the, exhibit list. Okay. Again, just quickly, you can see this. The difference between the exhibit list and the case docs is the exhibit list is what ODAR has put together as it's the record. What they're doing now is assembling the administrative record. And so if this case goes on to federal court or even all the way up to the Supreme Court, this is what the judges will look at. They'll see these are the documents upon which the case was decided. So if it's not in the exhibit list, it's not in the record. So you want to check this document and make sure that it is. The other thing you notice is that they actually give them document numbers. So it's 1A, then you go 1B, and information that you have submitted as well will end up being in here. These go all the way down through Section F. Section F is, I often think of that as the heart of the case because that's really where all the medical records decide. The tip is to make sure that you compare, for example, the medical records that are filed in case documents with those that are filed in the exhibit list. I've just had the experience where in reviewing a case, we determined that a record had been submitted and was just hiding out in the case documents list, and the judge's office had never put it in the exhibit list. And it turned out to be the key reason why the court remanded the case. They said that the client had filed this information, the judge had it, he should have considered it. So make sure that the information that you have filed, which starts out in the case document section, actually ends up being in the exhibit list as well. Okay. Again, get the C from ODAR or the claimant, it's encrypted. That means you're going to need, and also you have to have the passcode, which Social Security will give you. It will tell you how to unencrypt the programs, and you need certain programs to actually get it. So make sure that those are the more hearings you do, the more those things they'll become familiar to you. The next thing is get the barcode from OR and file your letters electronically. You can file medical records electronically. Some registered representatives can upload files directly to the claimant's electronic record. I'm not going to go into the details of who can do that. Not everyone can. If you're eligible for that particular program, it's worth going through the hassle of registering, which you would do with your local ODAR office. Then for filing evidence, I think that we've mentioned here Region 1, DSI, they have more restrictive evidence rules. They give you 75 days advance notice of a hearing, but they require that you submit all your medical evidence 5 business days before the hearing. You know, even if that rule doesn't apply to you where you're practicing, it's certainly something that is good to pay attention to. You don't want to be arriving at the hearing with 300 pages of medical records, 98% which are from 6 months earlier. Judges don't react kindly to that, and many of them will really dive into the medical records and are quite familiar with the record before the hearing. If a medical expert who's called in your case, then they will need time to review those medical records as well. I know some practitioners say that they like to submit everything 10 days before the hearing, and that's a pretty good request. The exception I find to that is the claimant's current medications. I find, at least in the Boston office, the judges want you to submit that the day of the hearing. And find out what your hearing office wants to do. And finally, pay attention to the language that your client speaks and is comfortable testifying in. You may notice that the client is getting all Spanish notices, and SSA ODAR on its own initiative will often order interpreters for the clients, but be proactive on this. If you find that you need your client speaks Hindi and some English, but is more comfortable in speaking in Hindi, then ask ODAR to order an interpreter. They are required to do so, and certainly they're used to doing it. And some of the judges, I find, they'll try to have the claimant testify in English, but it's quite right as to language of choice. Okay. So, what you want to do at this point is you've got your disc. You want to make sure that you review that file and see what they have for evidence and see what's missing. I often will separate a file out into really 3 separate areas. Personal, meaning, sort of where was the client born, their education, their personal situations. You may be representing clients who have had really very horrendous early life experiences, and you will need to sort of know how those impact their claim for benefits. Medical, that speaks for itself. Vocational, what is the client's work history? Again, that information you're going to get from your client, and it's also available in the record. What you have to do to prove benefits. You really want to know this at the beginning of your case. Is SSI versus SSDI? We're not going to go into the difference between those 2 programs, but know that they are. Is this a case where the client is applying for both those benefits, SSI or just SSD? Then, when you're looking at your case, the other thing that becomes important is your 5-step analysis, and Linda's going to go into more of that, as well as theory of the case. You know, theory of the case, you can call it by many different names. It could be an elevator speech. It could be a few sentences. How do you answer the question, Susie Jones is disabled because? You have to sort of come up with that, and then, you know, your basic job is to figure out, okay, this is why I think the person is disabled, and what information that I have to do to get it. And you have live testimony versus written records. There are certainly things that you're going to need to kind of pay attention to right from when you start to represent an individual. Another thing that's important at this stage is really interviewing the applicant. You may have done this if you represented the client either at initial or reconsideration. But again, this is something to kind of take a whole new look at the case and see where it's at. It should be internally consistent, and it should make a sense to the listener, and it should make sense in light of the medical and other evidence. And you really have to spend some time in thinking about this and the kinds of questions that you need, the kinds of information that you need to get from your particular client. You want to cover their work, diagnosis, prognosis, again, daily activities, lowered ability to perform competitive work. And those are the types of things that you're going to want to ask your client. And again, we've got that 5-step sequential evaluation. Think about that as a basis for the initial interview. And each of those, you can ask sort of specific questions on this. And the dial, and it's designed to help you get both medical, legal information for your theory of the case. I'm going to turn this back to Linda.
Okay. Well, developing the theory of the case is something that you should start doing almost from the get-go, and it will be a working theory of the case. Your theory of the case may change and continue to interview the client as you review records, as you develop new medical and other records. But it's important to be thinking about it really from the start. The thing that you want to think about is it working, or have they been working at an important period? You know, Sarah alluded to for Title II as the date last insured being important. You know, when the Title II, you need to know when that is, and you need to know whether what disability onset date is going to be, and whether the individual has worked at a time that will be fatal to the case. You know, you can't work in the 5 months. You can't work at the SJ level in the 5-month waiting period, which is counted from the date of disability onset, and then you also have to meet for both SSI and SSDI the 12-month duration rule from the date of disability onset, which also means no substantial gainful activity. I don't know how familiar you all are with the concept of SGA, but essentially it's measured by the amount of earnings. For people looking for disability benefits on the basis of disability as opposed to blindness, in 2016, SGA is presumed with gross monthly earnings of $1,130 a month. For people who are looking for disability benefits on the basis of statutory blindness, it's $1,820 in gross wages per month. So that's an important thing. And if the individual has also been working during the pendency of their application, that's important to know too, because when Social Security develops the residual functional capacity, one of the things that they look at is, well, what does the person do on a day-to-day basis? And so it's important to know what you're going to have to develop information around, what you need to question the client about, what you might need to, what problems you may need to solve in the case. So work is always a good place to start. And if you have the record already, as Sarah said, you can see the earnings, but the earnings record probably isn't going to be up to date that you get from Social Security. So you're going to have to question your client. Step in the sequential analysis then, do you have a severe impairment? Really this melds with all of your questioning on the client's current diagnosed conditions and how they affect them on a day-to-day basis. So for severe impairment, it's a de minimis test. There has to be something that, some diagnosed condition that has functional limitations that have an impact on the person's ability to work. So it should be an easy case to, an easy step to get past. Step 3 is, does the individual have a condition that meets or equals a listing of impairments? I always like to look in the listings, even though I don't think my client's going to have a condition that meets or equals the severity of a listed impairment, because I like to see what Social Security considers the most severe level of impairment and how close my client is to it. And in addition, there are head notes to all of the listings that explain what Social Security is looking for this kind of condition, some of the testings, longitudinal view considerations. So it's an important source of information for what you should be thinking about. The meat of most of what you're going to be doing, though, is at steps 4 and 5, where you're really looking to develop a residual functional capacity. What can your client do physically and mentally on a sustained basis? And what Social Security means by a sustained basis is hours a day, 5 days a week, the way most people work, and the jobs where they have to be there. We've already talked a little about duration. So you'll also want to look ahead at the grids. What's your client's age, education, and past work history? You want especially good information on your client's past work history. What were the jobs? What did they actually do? You want them to describe in a fairly detailed way what they actually did, and then try to figure out where they fit in the grids. What's their exertional capacity? Do they have mostly physical, exertional, functional limits, or do they have significant exertional, non-exertional impairments, or totally non-exertional impairments, which gets you off of the grid rules, which is important if using the grids would direct a decision of non-disability for your client. The grid rules can only be used to direct disability when the individual's impairments have mostly exertional limitations. Also, other SSA rules that you might want to, that you should consider. Actually, I think a little later on we'll be seeing a list of Social Security rulings that put together that I think are the most important ones to look at. Social Security rulings aren't regulations, but they are binding on J's, and they're also binding on the Appeals Council. So they're an important thing to know about.
Linda, you can, next to the exhibit list, the arrow, you can click that, and the SSR rulings is there.
Oh, I see. I clicked the wrong thing.
So you can click that.
Here we are. Here's a list of at least a partial list of my selected Social Security rulings. So at the very first one you can see is Social Security ruling 83-20. 1983 was the date that this was this ruling was created, and it's still good. It's about determining the onset date of disability, which can be difficult if there wasn't a sudden onset of disability. Unful work attempt, that's a good one. That's a good way to rebut the presumption of substantial gainful activity. Also want to look at Social Security ruling 96-3P, evaluating pain and other subjective symptoms. There's a lot of good information there that's helpul to know. Social Security ruling 85-15 and 16 and 85-15, 85-16 are great, give great tips on evaluating the basic mental demands of work and putting together a residual functional capacity determination for people with mental health impairments. 96-80 is assessing RFC and the sustainability requirement. It's another very important one, as is the one on the bottom of the page here, SSR 96-9P, creating an RFC for less than sedentary work, and the sustainability requirement. People who have a residual functional capacity limitation for less than sedentary work, really there's no work that they do. And then up here at 06-3P, how Social Security could consider evidence from SOAR conditions, another very important ruling. So I could go on and on about these, but I'll let you look at them yourself. And they're easy to find on Social Security's website, ssa.gov. Look at our program rules, and they'll be there. Okay, I think this next one, Sarah and I were going to talk about a theory of the case in a hypothetical situation. So take a couple of seconds to review this hypothetical case. And are you on?
Yeah, but you have to, I think only one person has the ball at once, Linda.
And I don't see the ball. What do I do with that?
If you expand the participant list on the right.
For you, Sarah and Linda.
They'll do it for us. Okay, there we are. All right, so this hypothetical client is 52 years old. He does have a high school education, but he obtained a GED. He has a history as a general laborer. He's a veteran. His disability onset date is 2012. Isn't any work after 2012 either. He lived in a shelter since 2013. And he says he has paranoia, daily migraines when he's around other people or needs to complete any tasks because of an IED explosion, which may have resulted in a TBI. There's data on this. He also fell off a ladder while house painting, which left him with limited use of his right hand, which is his dominant hand. So in terms of developing theory of this case, looks like there's evidence that's missing, but I would start with, this is probably a listings case, and I'm going to have to look at grids for his education and his past work history, which I would need to get, figuring that I would have to show he can't, I would have to show that he cannot do any past relevant work because of his current residual functional capacity for sustained work, and that I also have to show at step 5 that there isn't any other work that he can do on a sustained basis going. What do you think, Sarah?
Well, when I look at this, I would agree that I don't see anything in just these facts that it would be a listings case. I like to always take a look first at age, education, as we know it, and work experience. So he's 52, so we know under the grids, if he were limited to sedentary work and had a limited education, he would be disabled under those grids. But the question, one that I would want to investigate is, what is his RFC? Is he, there isn't really any, certainly his past work as a laborer would indicate that that's probably light to even medium work, so he was used to lifting things. And so, you know, is there anything other than the falling off the ladder that would limit his ability to lift things? Now, it might be, certainly, if the injury to his right hand is really, depending on how bad that is, that might be really significant because that could be a pretty limiting factor for certain types of jobs.
Right.
No, it looks like he would be still eligible for SSD. The rule of thumb is you're insured 5 years after you stop working, so that would be through 2017. That's really good news for him if he does qualify for SSD. Remember, if you have minor children who are dependent upon you, you can get those benefits. You know, and I guess the other thing is, so he didn't work after 2012. He's residing in a shelter, and what's that all about? Is that because he has no one else to live with, no other access to housing? Is that still continuing to you know, through today? Yeah. And migraines. I think those are also something to further investigate. What do you think of those, Linda?
Well, yes, I think there's an indication that he has some severe non-exertional impairments. Certainly the paranoia could be an indication of mental health issues. It could give him trouble performing even sedentary work. Daily migraines, if that's documented, people who have migraines often miss a lot of work, would be off task at work, and may not be able to perform, you know, significant activities. With any documentation of the TBI, but it might be worth looking into whether there could be some testing to document that. But it certainly looks like a case where, depending on what the evidence, whether the evidence supports allegations, that it could be a good case for disability.
I'm going to pass the ball back to you, Linda. I think you're still up.
So this is really kind of this next slide is really a wrap-up of, you know, what you look at. Is the client working for all the reasons we discussed? Is impairment severe, meaning that it has more than a minimal effect on the ability to work? Instigate the possibility of meeting or equaling a listing. Getting a good discussion, getting a good description of his past relevant work, so you don't neglect that step. You can lose it past relevant work if you don't show the person can do it. And then getting together your arguments for whether there's any other work in the national economy, as we just recently discussed. And I think in this case, the individual can make a successful claim given his hand impairment and the migraines and mental health issues. He probably queue his relevant work, and I think there's a good argument that he he wouldn't be able to do other work in the economy either, particularly if he's limited to sedentary work. And that, Sarah?
I think you know, the only question that pops up is on the paranoia. You know, and if he's got paranoia, it seems like he may have some additional mental health limitations.
You'd certainly want to investigate that. Yeah. Okay, I think we're moving on now to the couple of slides. These are really important. Social Security published a new regulations last year that clarify their rules on evidence submission in disability cases. And what the rule is, that it's the claimant's duty to inform Social Security about any evidence that is relevant to the claim for disability. The old rule used to be about whether the evidence was material, which led to a lot of nations around whether a piece of evidence that wasn't particularly favorable was in fact material. Now that's a low standard. It's just whether it's relevant to the claim for disability. It does include unfavorable medical opinion letters or other pieces of unfavorable evidence. So the duty is to inform Social Security about all evidence that relates to the question of disability. It is the appointed representative's duty to help the claimant meet this duty to inform or submit all evidence that relates to the question of disability. There are two limited exceptions to this rule. One is usual attorney-client privilege. So the rep's analysis, an oral or written conversations between the attorney and the claimant, these don't need to be submitted. These are exceptions to the rule, and Social Security has made clear that this new evidence rule applies to non-attorney reps as well as attorneys, and the exceptions also apply to non-attorney reps as attorneys. And there's something called attorney work product, which is often in the law an exception to the duty to have to submit something, but here Social Security reads this very narrowly. So the way this would work out is that an attorney or a non-attorney rep could have a conversation with a medical provider about what they think the issues are for their client, what the diagnosis is, what their functional capacity is, and that phone call is not something that has to be disclosed. But if the information is reduced to writing, then that is something that would have to be disclosed. And there are sanctions that apply for failure to comply with this rule. And you can also see an HALEX rule, which is I-2-5-1. So it's I-2-5-1. So important to be aware of this rule and explain to clients that you do have to submit everything that is relevant to the disability question that is subject to attorney-client privilege or that has been reduced to writing. And unless something else to say, that is the presentation, and we're ready to take questions if there are any.
Yeah, I think that's it. So, Pam, I think were you going to guide us through the questions?
I just wanted to point out that we have some available resources that Sarah put together for us, and move on. We did get some questions coming in, and also the presenter's contact information is here as well. Slide, please. Yeah. If you'd like to ask a question, just go to the Q&A panel. Top, you'll see Q&A, and you can put your question in there. And if we do not get to your question, we will make sure that we distribute it to both Linda and Sarah to answer it offline. Okay, so we have a question that came in earlier, and this one would be for Linda. Are VC video hearings really being heard quicker anymore? Is it still taking about 2 years in of our areas for a VTC hearing to take place? So it sounds like it's taken 2 years. So the reasoning behind the video hearings were to speed things up to get the hearing quicker. So Sarah or Linda, do you have any advice or information on video hearings and the wait times?
Well, I think that the wait times are going to vary for both VTC hearings and in-person hearings. And here in Massachusetts, we never have VTC hearings, so I only know what I hear from other areas. I think it's important to check in with other practitioners in your area. You know, if the VTC hearing really isn't any longer and your client prefers the in-person hearing, then, you know, you reject it.
I think we have to remember that there's about 1 million people nationwide who are waiting for hearings. So I suppose what's happened is that even with the VCT hearings, the wait list has grown longer. But again, I think that would be something that would vary from office to office, and you should actually check to see on the available resources exactly is the wait for your particular hearing office. And, you know, you may find, for example, that, time passes and your client's condition has worsened, and they may now meet a listing, or you know, I think, you know, we had given a list of, you know, other ways to get an on-the-record decision while waiting for an in-person hearing, and try those.
Right, the dire need, you know, if the client's case really deteriorated and they might be done, then it's a Terry case. If you doubt your client has 100% veterans disability assessment, that's a case for expediting. So, you know, certainly dire financial circumstances, although I think there's a lot of dire financial circumstances in the backlog, so those don't work as well as they once did.
Okay, thanks for that, you know, really, really detailed answer. I think that really answers it for folks that live in various regions around the country. So we have a second question that came in. It involves the 40 quarters of work to be eligible for SSDI. And the question is, how do we get around the SSDI requirement of 40 quarters, 10 years of work history when the client has not been able to hold down a position due to behavioral health issues, yet is also denied SSI because he or she is deemed not disabled enough? So how would you answer that question if not enough quarters for SSDI and SSI, you know, due to probably not medical? It sounds like due to medical reasons, did not meet or equal a listing.
Well, I mean, there's no way around the lack of insured quarters if the client doesn't have them. Younger people need fewer, people under age 31, but anybody older than that needs, you know, to have earned 40 quarters, and not only that, they have to have worked in Social Security tax work pretty close to the date of disability onset. So if it looks like there is a case for disability on SSI, if the person is financially eligible, then it's working at the evidence to try to document the disability. You know, SA denies a lot of people initially that, and some of the cases with additional development can be won. Require full analysis of what appears to be going on to figure out whether to go forward with the case.
Another type of case that we see is where somebody's date last insured is in the past, and they have, and they can't. Maybe it's 10 years prior to the date of application, and in that case they would be denied not because they didn't have the 40 quarters, but because they didn't have they weren't disabled prior to the date last insured. In that case, if the person was financially eligible, and you would still be able to go ahead and improve disability based on SSI. I think that's also a common scenario that we see where somebody has applied for both. And I know our DDS has sort of told us that when people go to the district offices and file an application, the district offices will kind of jump through hoops to try to find if there's any basis to at least take a Title II application, because that's not a needs-based program, and so they're always looking for something other than SSI, which is the needs-based program.
Thanks for clarifying that question. Here's another one. While an attorney or non-attorney is recommended, is there any benefit at all to a client representing themselves? Never a good idea, right?
I guess I think that's really the way I look at it is that is really a decision for the client, and they want to have that's a decision that sort of the need to make. And, and certainly sometimes what happens in our office as a legal services office is that somebody calls up and they simply are not we just don't have the resources to take the case, even if it's a meritorious claim. And in some instances, we're able to look at that case, give the person some advice, and they go to the hearing. And we certainly have had people we have turned away who have successfully, won a disability case. But that doesn't always happen, and so I think it probably depends on, but on the other hand, some people are impatient and they don't want to wait, or, you may have a disagreement with your client over, how to present the case. And so if that's the case, then it's just, kind of not going to work out. So I guess I'd certainly always encourage the claimant to go to the hearing if they want to do so. Certainly it may be better than, just dropping the case. The danger I think that you run into is that people just don't, present all the evidence that they really should. I think that's particularly true in cases with mental impairments. Or where the client has symptoms of pain or fatigue, things that you can't see.
Right. I certainly agree with that. I think, most people who aren't steeped in this don't really know what they present. And some people are also, when they're in the hearing before a sometimes gruff ALJ, they are intimidated and are not able to present the case the way that they need to. So certainly it's always the case that a person needs some information about what they should do and how they should present the case. Yeah. And as Sarah said, sometimes that works out.
Yeah. Well, for your thoughts and opinions on that topic. We know that often an ALJ will adjourn a case so that the individual can obtain legal assistance. But you're right, make sure that the applicant weighs their options and is informed is really the way to go here. So thank you for that. We have another question that could go to either of you. So the question is there a ruling, HALEX, POMS, or SSR that requires, in quotes, that the ODAR scheduling staff notify us, the representative, ahead of time? In quotes, most of the time they call prior to scheduled hearings. We are in Region 5. I usually do 20 to 30 hearings per month. Thanks.
Goodness. I don't think it's a requirement. I think it's a best practice that some ORs do, and it's always beneficial when they do, but I don't think Social Security requires it. I don't think it's anywhere in a rule. Do you, Sarah?
Don't. And also, I think actually, cases get assigned to individual judges. And so the judges control, at least in the Boston regional office, the judges control their own scheduling. And so if you've got 14 judges, you've got 14 people who have different views on kind of scheduling. I remember a number of years ago having a conversation with the person who was then the chief ALJ in our office, the Boston office, and I think, the question for him was, if people agree to a hearing date, are you likely to have fewer continuances? Because I think the continuance issue is the thing that really, sort of is the monkey wrench in the works for ODARs, because once they schedule a hearing, these days there's often a vocational expert, there may be an interpreter, there may be a medical expert, although much less frequently. And so once you start scheduling those other people as well, it's a problem. So for VEs, for example, maybe it's, they want to schedule somebody because it's a, neurologist and they want to try to do, all his cases on one particular day. So I think they look at it from that perspective. I guess the only thing that you can do in that case is really just try to, be proactive and call the judges on each and every case and let them know. And certainly where I've gotten notices where I haven't been notified and I can't do it, I will, sort of say, I can't do it. Here's I'm already scheduled to be elsewhere that day. I have a, long-staying vacation. So the judges will sort of, I think,
and the earlier you ask, the better.
The earlier you ask, the better.
Thanks for that answer. We're getting several questions. People are really eager to get on the Social Security website and find these grids. And we are just clarifying that these are actually called the Medical Vocational Guidelines. So we're providing the SSA link to folks for that.
Great.
Can you share a little bit more about the Medical Vocational Guidelines and how helpful they can be to an applicant that may not meet or equal a listing? And again, we hope to do a more in-depth webinar maybe down the road on the topic of the Medical Vocational Guidelines.
Well, the grids can either make your case or kill your case, and so it's always important to look at them. And they're a set of 3 matrices: exertional limit, sedentary, light, medium. And so the first thing, so that's where the RFC comes in. What Social Security think that the RFC maximum is. There's age, education, and prior work history, which is all specially defined in the regs and also in the head notes to the medical vocational guidelines. And so those facts are important. Once you have those facts, you plug them in to the matrix and the relevant one, and it gives you the answer, disabled or not disabled. And you might be happy about that if it's disabled. You're not happy about it if it's not disabled. And then in that case, what you want to do is to figure out whether there are any significant non-exertional limitations that take you out of the grid and require an individualized determination. I see the POMs that you've got online. That doesn't show us the matrices. The grids are actually in subpart B of part 404, and
they're regulations.
They're regulations. So you have to go to.
We can view that site.
We'll give you those sites.
And then you can post that, because I think that people should, be aware of those, as well as certainly POMs are very useful. The other thing is that on Linda's list of SSR rulings, SSR 8315 is the grids as a framework for non-exertional impairment. That certainly would be very useful for people to look at.
Right. On the grids, but it's important to look at them, review the head notes when you get the link. It has a lot of information about the rules for using them. Always a place to start in your case. What do I have to do? What do I have to show for my client to win at 5?
If you go back and look at the DE, the Disability Determination Explanation, in there, the DDS has actually given some other, they don't sort of reference the grids, I think, explicitly. They talk about probably step 4 and step 5. Can you turn to your other work, or if not, are there other jobs in the economy? Those are useful to look at too. When it's a little different than I think the grids, but it's very useful to look at.
have a question here. What happens if an applicant's diagnosis has changed? I have an applicant that was sent to a specialist, and the specialist disagreed with the initial diagnosis.
Well, that happened, especially with difficult to diagnose conditions. Further testing, maybe something new comes up. Whether or not that hurts the case depends on what the second diagnosis is. So, I mean, it's not necessarily a bad thing that the diagnosis changes. You need to show the reason for it. You've got your specialist who's now looked at it, and here's what it is, and here's what this diagnosis means. This person has always had it, if that's the case, or maybe it's an exacerbation of a case of a prior condition that's now morphed into something else. So all of those are important medical facts to document and figure out and see how it plays into the case. Is the new or the clarified diagnosis, does it result in even more significant functional limitations or severe implications? Yeah.
I think that SSA, what SSA requires is that an individual have a medically determinable impairment or combination of impairments, and that's really what they're looking for, as opposed to diagnosis A or diagnosis B. So you want to make sure that whatever it is, that it's certainly if it's a diagnosis that's recognized, will be a medically determinable impairment. And as Linda said, what are the functional limitations that causes?
And that's a great, this is a great point to end on, because as all of you know in the SOAR community, we focus not just on the diagnosis, but how it impacts functioning. So it's more than a diagnosis alone. We have many more questions that we didn't get to, but we are at 4:30, so we'll be sure to distribute the questions to our presenters and see if we can answer some here ourselves. I just want to, just again, thank our presenters, Sarah Anderson and Linda Landry, for taking the time out of your very busy schedules to present today. Your knowledge is just really broad, and I know our community has learned a lot about hearings, and we hope that there will be a part 3 down the road, which focuses still on preparation. Before we get to the presentation, there's still so much more to learn. So I just want to make a quick reminder to complete the brief online evaluation after today's webinar. And for more information on this topic, please visit the SOAR website at soarworks.prainc.com, and to contact the SOAR TA Center by email, soar@prainc.com. So we'll be sure to direct any questions or comments which would not be answered to our presenters for their responses. Thank you very much, and have a great rest of the day.
Thank you.
Thanks.